We have broken down the event in two content-related panels, two discussions. The first will focus on the importance of independent judiciary for the state of law, and the second, we will talk about the rule of law in Europe. How can it be best secured? The first panel discussion will be moderated by Armin von Bogdandy, doctor and director of the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, one of the most important international lawyers of the latest generation, 2008, for his outstanding scientific achievements in the field of basics of law and economy. He was awarded the prize of the Berlin-Brandenburg Academy of Sciences. This part of the event, however, is opened with two keynote presentations, and we would like to begin with Professor Dr. Małgorzata Gersdorf, a former president of the Polish Supreme Court, and Dr. Ulrich Maidowski, justice at the German Constitutional Court. First, we will play a video of Professor Dr. Gersdorf. Between 2014 and April 2020, she was the president of the Polish Supreme Court. She was against restructuring of the judiciary by the PiS in 2018. She was pensioned off but refused to go into pension in April 2020. Her office ended, and in 2019 she received the Theodor Heuss Award. We will now listen to her video message.
Dzień dobry Państwu. Przede wszystkim chciałbym bardzo.
Good morning, ladies and gentlemen. I would like to very warmly thank you, first of all, for the honor to be invited to this conference. I would like to ask a theoretical question. What can be said about a country where such things happen, like dismantling of the prosecutors, of the constitutional courts, and of the regular judiciary? Furthermore, the carrying out of disciplinary proceedings against justice, and that according to the will of the Minister of Justice, who is also the general prosecutor in the country at the same time, and the dismantling of the Supreme Court, where a court is working inside the court, a court before the court, namely the disciplinary division of the Supreme Court. When we look back to what has been achieved in the European Union, to the theory and philosophy of law, we will discover that a state of law has the following fundamental features: equal treatment of all citizens and regular jurisprudence by independent courts. And this is a fundamental feature scientists of the democratic world point out. A state that is based on an individual prerogative is sanctioning the principle of independence, of non-involvement of the central place by legal regulations which serve the purpose that at the personal request of the highest people, punishments are imposed and proceedings are initiated. That is a state where the dignity of individuals is trampled on by, for example, these people are treated infamously without having been given a sentence, and only by the media and hate speech these people are hit. Such a state cannot guarantee its citizens' security. The state uses fear rather than the law, which is very sad. Unfortunately, today's Republic of Poland, a member of the European Union, is like that. Even not quite so, but it is following this route. We know that the independence of the courts and their legislative constitution are characterizing the courts in a democratic rule of law in Europe. I would like to describe a few mechanisms to underpin what I have said, which have an impact on the courts in Poland and which allow it to the government to influence the course of proceedings in courts. First of all, staffing of the courts with judges. The eyes of the mythic goddess of Themis are covered. And this can be interpreted in two ways. On the one hand, as the prohibition to influence those who conduct proceedings, and also the the necessity of being unbiased. At the beginning of the Right and Justice Party, its boss, Kaczynski, secured that for him, effective work and the independence of the courts are very important. Of course, he introduced something very different. Instead of the alphabetic assignment of cases to courts, he introduced drawing of lots by a computer to assign cases to the courts. So this algorithm is on a basis that has never been disclosed. There is a saying that if certain mechanisms are introduced by people, they can also influence by people. But this is not all. There are courts to whom this mechanism doesn't apply. It's the Constitutional Court and the Disciplinary Division of the Supreme Court, namely very important panels of the judiciary. This is the first critical point. The second critical point is the administration of the courts. The Minister of Justice, who, like I said, is at the same time the general prosecutor, had 6 months' time in order to exchange the presidents of the law. And this is what he did. 120 presidents of courts were exchanged against others in this short time of period, irrespective of their ability and professional background they have. They were just exchanged, replaced. And it's not the case that it doesn't matter at all who's the president of a court, because a court president has a major influence on where a judge is active in what division. The president can put a civil judge into the criminal department, or, what is perhaps the worst punishment for a judge, he can place a criminal court to the family law department. And someone who has been familiar with criminal matters is a very good lawyer and suddenly has to deal with family matters, with childcare. It can as well happen that the transfer of such a judge means that he is deprived of his cases, especially in criminal matters. So all this needs to be reopened, which means a statute barring is imminent. So a president of a court, that's a very important person in organizing justice. And such a court president is under the influence of the powerful Minister of Justice. The third critical point concerns the system of promotion and appointment of judges. Today, these exclusively depend on the State Council of Justice, KRS. We call it Neo-Council of Justice because the State Council of Justice is unconstitutional. It has been appointed through and by political bodies, and this council is not what our Constitution refers to. So all appointments of judges on the motion of this council are not correct, in our view, at least. My fourth point, disciplinary matters. Disciplinary matters depend a lot on the Minister of Justice, that is, on the general prosecutor. The disciplinary proceedings against judges are heard before the disciplinary division of the Supreme Court that has been set up by the State Council for Justice. This says everything. That means the division of disciplinary matters can change the contents of a sentence. The rights of the defendant are smaller than a person that is being sued for killing. So what is the most important thing? In what I have already said, I dealt with what has taken place, but it's continuing. What is most important is the disregard for the judgments of the European Court of Justice. Even punishments are imposed because of application of these courts' sentences. In 2019, the European Court of Justice, in response to a prejudicial question filed by the judges of the Chamber for Labor and Social Matters, the answer was was that the judges should themselves judge the Polish judges to see whether the judges appointed by that council are independent. In the answer, there were also several pieces of information as to what the judges should pay attention to. The judges at the regular courts and the Supreme Court, represented by 3 judges of the Division for Labor Matters at the Supreme Court, hence pass a sentence or a judgment on the basis of the European Court of Justice. And because of that approach, disciplinary proceedings were instigated against these judges, which were, however, argued by several and different reasons. And newly appointed divisions of the Supreme Court, in disregard of the judgment of these 3 judges, passed their judgment without that, even though this judgment was excellent. So, upon the motion of the first chair of the Supreme Court, a joint decision was passed by 3 chambers of the Supreme Court, according to which, in brief, the disciplinary division of the Supreme Court is not a court. So this decision was made on the 23rd of January of 2020. The European Court of Justice in April, on the 8th of April, suspended the activity of the disciplinary division. The judgment of the European Court of Justice applied to all state organs, so also for the first president of the Supreme Court. Thereby, the first president of the Supreme Court ruled that the disciplinary division must not pass any judgments anymore. Unfortunately, this ruling immediately after the period of office of the first president of the Supreme Court ended, was changed, namely by Zaradkiewicz, a judge who was temporary first president of the Supreme Court. He was to start a general meeting of the judges in order to appoint the new first president. This was not within his competence. He was not allowed to do that. Irrespective of this judgment, the disciplinary division continues to pass judgments against prosecutors, solicitors, and it also passes judgments about the removal of the immunity of a judge, even though they say it's not a disciplinary matter, but this is wrong. The 5th point is most important. The role of the Constitutional Court in implementing the projects of the government, which pursues the goal of dismantling the independence of the court, including the Supreme Court. After the 3 divisions of the Supreme Court had passed judgments, the executive found that it was now the time to turn to the Constitutional Court, with the rationale that the Supreme Court has exceeded its jurisdiction with this judgment and has started to create new law. That means that the judgment of the 3 divisions is non-existent. Of course, the Constitutional Court, totally without any reasoning, accepted this concept of the minister-president, of the premier, and thereby exceeded its own jurisdiction, because it's not their task to pass judgments about judgments of the Supreme Court. So this court intervened with the jurisdiction of the Supreme Court. So we are today living in a system that has the features of authoritarianism with some elective possibilities. Elections do take place, but those in power have all competencies and all powers to decide all matters of the citizens. In the end of the day, I think that we will not disappoint Europe. We will remain a state of law, and the Polish judges are certainly aware of the obligations they have taken on. Our entire population has been involved in the meantime. It is being supported by the European states, and in the dark time of the war later on and also now. And I thank all Europeans for that, the European member states. Thank you for that, and I count on further support of our population. Thank you so much.
Herzlichen Dank müssen wir.
Many thanks, we have to say. This has been pre-recorded for this event, for these very interesting times that we are running. As a next speaker, we may be able to welcome Mr. Dr. Ulrich Maidowski. Since 2014, he's a judge at the German Federal Constitutional Court after having studied law in Tübingen, Aix-en-Provence. He was working as a judge at the Administrative Council in Aachen and later at the Higher Court in North Rhine-Westphalia Austria, and then being a judge at the German Federal Constitutional Court. I'm really delighted to have you here in order to talk about the independence of the German judiciary. Many things. I hope we won't have any technical issues now and you will be able to hear me now. We have just listened to the statement from Ms. Gersdorf, and between realism and pessimism, and none of us, it's exaggerated. Unfortunately, we have to say so. But nevertheless, let me try to enrich this picture with two more colors. I always need, and I guess we all need, despite everything, our idealism and just a little bit of optimism. However, the question that we have to answer remains the same. Who protects the independence of the judiciary if governments or national courts do not perform this task, if they even actively endanger the independence of the judiciary by invoking a problematic understanding of democracy? This question is part of the pan-European reality, but we are all affected by it. In such a situation, hope is not only directed at state institutions, but in a special way as well at the European courts. However, in light of the current events, the question has also been raised as to whether the German Federal Constitutional Court, a member I am, has rendered the task of the courts, and in particular the European Court of Justice, as guardians of the independence of the judiciary, more difficult or even impossible through its PSPP decision of the 5th of May 2020. But before I take position on this question, I would like to make 4 brief remarks on the rule of law, which may seem all too easy to you, who are all experts, but which are very important to me, nevertheless. First comment. We are all subject to the rule of law. The rule of law does not only need the contribution of the judges, the public prosecutors, the authorities and the government, but especially the trust of the people and a feeling for constitutional values and fairness in the classical and social media. This includes the willingness to offer constructive criticism and to accept final decisions by the independent courts, even if they're considered wrong. And only in the interaction of all these contributions is when the rule of law is created. This means, however, that the protection of the rule of law cannot be achieved by one of the above-mentioned parties alone. We need all of them. The second comment, the rule of law tolerates diversity. Not in all the different countries of the EU or convention states. The rule of law does have to be understood and practiced in the same way. Anyone who talks to colleagues around the world knows about it. And evermore, the same rule can work well in one model of the constitutional state, but be highly problematic in another. Who wants to protect the rule of law must maintain this flexibility and diversity. Third comment, the rule of law needs red lines. For despite all its diversity, the rule of law is not something arbitrary. There are basics which are guaranteed in every system and which must be essentially the same. These basics concern above all the central place or the central venue where the rule of law must prove itself, and that is the court, including, of course, the position and the status of the judges. If one of the most important substantive aspects of the rule of law is the need for independent control of sovereign power, then this is the red line that must never be crossed, despite all legitimate differences in the details. And especially, we have to be able to find a way to bind the rule of law against the judges. And fourth and last comment, judicial independence can not only be endangered from outside, but also from within. Of course, government and parliamentary majority, a one-sided media landscape, or a loss of trust among the population are powerful factors in the dismantling of an independent judiciary. But the erosion of the judicial independence also takes place independently of these factors in the midst of the judiciary itself. And this happens in sometimes a spectacular manner and sometimes in an everyday manner. And I'm talking not only about judges who are deliberately infiltrated into the courts as compliant executors of an anti-justice policy, but I am also talking about colleagues who see judicial independence as a privilege and not as an obligation, who are arrogant towards the parties to the proceedings and who place procedural rules at the service of their own convenience. In other words, those who work unprofessionally. The protection of the judicial independence must also start here, through the anything but self-evident ability to criticize colleagues and even to accept criticism. An important aspect of this is the ongoing dialogue on judicial ethos. Let's now come to the decision of the 5th of May in 2020. The decision of the Federal Constitutional Court has been warmly welcomed by the Polish government. And many critics therefore accuse the court of having shown to the Eurosceptics, the populists, and the neo-nationalists an easy way and a comfortable way to ignore the European Court of Justice, citing the German example, and this at a very inappropriate time. I am totally convinced that this accusation is unjustified, and I would like to give you my reasons for this conviction, but 5 aspects are important to me. First of all, the strengthening of the European Court of Justice is one of the aims of the decision. Of course, one can either agree with the decision of the 5th of May in 2020 or view it critically. This applies to the statement of the Federal Constitutional Court on the European Central Bank, as well as those on the ECJ. However, my conviction that this decision does not support the position of the Polish government is completely independent of whether one joins the camp of the critics or that of the supporters. A close reading of the text, which, after all, is around 40,000 words long, will reveal that this ruling is not intended to weaken the ECJ, but to strengthen it. But I see already that I have to explain that. The second aspect, the competence and the jurisdiction of the ECJ are totally undisputed. This is not something that we dispute as the GFCC. An important part of the decision of the 5th of May states that the ECJ obviously has exclusive competence to interpret union law in a binding manner. And this is not a lip service. This is not something we read from the textbooks, but it is a continuation of Hannibal and very seriously meant. With the PSPP decision, we are moving in the area of a very rare, extremely rare exception. And this alone shows that our decision must not be used to justify a detachment from the authority of the European Court of Justice at will, in a specific will, or even in general. Let's now come to the core allegation that we have raised. It might be quite surprising to hear that we see insufficient legal protection. In our understanding, the ECJ based its decision on the PSPP on the facts as presented to the public by the ECB. That the decision of the ECJ is not part of this category. And the fourth aspect, strong words as a protection against unjustified criticism. How can we deal with it? Why is the PSPP decision so, let's put it like that, rudely formulated? Why why do we write no longer comprehensively or objectively arbitrary? I may say that these are not really diplomatic formulations. Maybe we're really not that good at that. But those rude formulations protect the ECG from unjustified criticism. This might sound strange at first sight, but it is correct because we have a very high threshold of objective arbitrariness that must be accepted. Everything underneath the threshold that may be considered right or wrong has to be accepted. The example of Poland makes it quite clear, I think. What the ECG has stated in its decisions on the rule of law in Poland certainly does not reach this threshold. And this is why the Polish government may find wrong what they hear from the ECG, but it is bound by it, may they like it or not. The fifth aspect, just quite briefly, accusation of a deficient factual basis is considered typically German. Critics say we have a typically German understanding of procedural law, which may not be transposed to the European law as a whole. This is not something we take for granted. We assume that even according to the European understanding of fundamental rights, effective legal protection depends on the court not only issuing an expert opinion, but assessing the specific case. This also includes the precept of audiata et altera pars. It is not in keeping with the ethos of the judge to accept the assertions of a party on the facts without examining them. This can only be done if the procedural law allows to do so. So in the validity template under Article 267 of the TFEU, such an instrument is not pertained. And in order to work with solid facts basis, we need the rules of procedure. Let me now finish with an image. I think in the dialogue of the courts, there is no simple solution. The ECG, of course, is the one issuing binding rulings on the union laws, and the Constitutional Court is then finding the way to interpret the national law, the national constitutional law. But they look for a collaboration. Let's just imagine the ECG and the German Federal Constitutional Court as two friends who undertake a walkabout. And here they find a very nice but a bit mythical building, the European house with many rooms that we've been talking about for such a long time. It's already a bit older and with many extensions. The two friends to explore this building. The ECG looks at the inside of the building and the GFCC at the outside. And this then leads to neither of them seeing the whole picture of the building. They cannot make a very appropriate and wholesome description of the image, which is only possible when they meet once and again during their exploration and exchange their impressions and findings, the way we do it today at this nice event. So thank you very much for your attention. Many thanks, Dr. Maidowski, for your input, not only for the imagery in the ending, the friendly walk that we entertain in the end, and as well for the explication and description on the ruling of May and what was at your heart when you formulated this ruling. Throughout the upcoming debate, you will be able to participate with answers and, of course, questions as well. So we will be part of the discussion in your position. For the further debate, I would now like to welcome the moderator Armin von Bogdandy that I already introduced. Further participants is the judge Włodzimierz Wróbel, who is the judge at the Polish Supreme Court, Dr. Angela Nußberger, the well-known expert for comparative law and international law. She has been a judge at the European Court for Human Rights. In 2020, she has been appointed one of the three international judges at the Constitutional Court in Bosnia and Herzegovina. And then she is an extraordinary member of the Venice Commission of the European Council, who are assessing the states of Eastern Europe in constitutional affairs. Grażyna Baranowska will be our representative of the audience. She is the perfect person for it because she is fluently speaking all three languages of the event. I would now like to hand over to Mr. Armin von Bogdandy, and I would like to hand over this debate due to a few technical issues. I would now like to ask you to take over the 10 minutes of break that we have presumed in order for those people having an online connection being able to get up and get a coffee themselves. So, Mr. von Bogdandy, I hand over to you.
Good morning, everybody. Welcome to this panel on the issue that there is no rule of law without an independent judiciary. As has just been mentioned, we now have two presentations, which to some extent will also be a reaction to what we have just heard. Then Judge Maidowski might come in as a reaction to these two presentations. And then we go into the discussion, and Dr. Baranowska will present the questions. We have time up to 11:50. I am informed that we need to finish precisely because politics are waiting. So without further ado, please, Judge Wróbel, give your input into our discussion. Thank you. The floor is yours.
Thank you very much, and thank you very much for the invitation in this very interesting, I hope, debate and discussion. I will start with only a few words, because I think that it's more important just to debate on these topics than just to present the fixed thesis. Professor Gersdorf, our former Chief Justice in Supreme Court, described the essence of the crisis we are dealing with in Poland. These symptoms are visible, I think, not only in Poland, but in many other countries, not just only European, I think. And this is the basic question for me. Are they specific to a given country, or are they a sign of a more general tendency we are facing? So personally, I am in favor of the second position. The source of the nowadays crisis must be traced to cultural and technological transformations of the last decades, especially regarding, I think, communication. They directly affect the crisis of many institutions and principles of the modern rule of law. It is enough to mention the threats of manipulation that we observe in the elections or votings in many different countries. Probably in brief, this crisis can be described as a new populism, I would call it, technological populism maybe, versus the traditional rule of law and liberal democracy. It seems that the attack on the independence of the judiciary cannot be analyzed in isolation from the roots of this basic crisis. So, asking the question was posed, what can we do or what should we not do in this situation? So apart from describing the consecutive, more and more depressing symptoms of the crisis, so Professor Gersdorf didn't mention the new events in Poland with appointing of the new Chief Justice of the Supreme Court, also with the violation of the Constitution. So maybe it is worth to try to understand and analyze its causes, the roots of the crisis and the mechanism of its emergence. Perhaps it would require separate long scientific debates, but personally, I see these reasons, these roots in two perspectives. First of all, the attack on the independence of the judiciary and on judges, literally, is a characteristic attack that populism makes on institutional authority, on elites, on social group that can be cast as public enemy, caste, oligarchy, and concentrate negative social opinions around it. The need to fight such a group is an essential fuel for populism as a way of gaining power and maintaining power. Refuting authority brings emotional satisfaction. It is sensational. Judges, with their splendid isolation, silence, mysterious costumes, palace buildings, mysterious rites and language, are very suitable for this purpose. The populist revolution needs aristocracy that can be overthrown. High-earning lawyers are also great for emotional assault. Discreditation, that's what works. The work of lawyers seems unnecessary because it is only a complication of simple things settled according to the standard of common sense. And the common sense criterion is dictated from elsewhere, but continues pools and spin doctors. Second perspective, the attack on the independence of the courts has a more classic and prosaic reason as well. Populism wants to take control of those institutions that may limit its ambitions. Independent courts attached to the value of liberal democracy and the rule of law are a natural obstacle, especially constitutional courts or supreme courts. Under the slogan of a moral revolution, right-wing or left-wing, it really doesn't matter, a revolution of ordinary people by subordinating the courts to political power, populism, on the one hand, abolishes the control of law over the activities of the political executive or parliament. On the other hand, it provides another means of communications. They have, the populism itself, they could use the court rulings. Contemporary populism is realized primarily in the sphere of communication using modern technologies. Thanks to them, it is possible to ignite and manage emotions, negate knowledge and rationality, produce hate and fake news, manipulate people. And the essence of the court's activity is also communication. Judgments are messages. For modern populism, a communication tool such as courts is necessary. So I come back to the question, what can we do? What should we not do? First, the paradigm of thinking about the authority of the court must be changed. Get out of the wedge and mystery paradigm. Open up to contemporary culture. So what to do? Change the language of communication. Change the way we justify our judgments. We should be active participants in public debate, where it takes place, also in social media. Legal decisions, our judgments, our verdicts must be able to be described in moral terms, conflicts of values understood by ordinary citizens. The application of the law cease to be legitimized solely by the fact that it was adopted by the competent authority. It is not enough today. Statements of courts must make contact with the contemporary culture, also popular culture, in the language and emotional rhetorical layer. The courts are to administer justice. The administration of justice is not only the normative content of the decision in the world of values. It is not always easy. It is this judgment, verdict, is also, and perhaps above all, a message about what is fair, what is just, what is good. The decision in the world of values. It is not always easy, I understand. Does any of us explain to someone who came to the court the axiological reason of our decision for rejecting his complaint because he didn't met the formal criteria? Does anyone, apart from a formal reference to the legal provision, explain what these formal conditions are for? Lack of time. Yeah? People will then listen to the lawyers if lawyers draw them into the world of values that citizens can recognize emotionally. Second, or third now, education. Court must be open. Judges must be present and recognizable in schools, in social organization, in educational activities at all levels. Visitors must scroll through the courts. The court's success, the real success, is the audience in the courtroom, not the empty rooms full with the lawyers. Because only then we have someone to talk to. and explains the sense of the rule of law. Fourth, acknowledgement. So the first manifestation of the threat to the independence of the judiciary is the refusal of acknowledgement by the executive. The verdicts are not respected. The political power undermines their rationality. Public officer discredit the judges personally. Criminal or disciplinary liability or measure for the verdicts, for the judges, for what they are doing. Because the courts have no real power. Convention, rather, is the natural environment. Conventionality, legal meanings. We speak the words of judgments that matter and change the situation of citizens only if someone acknowledges it. As a rule, it is about the executive. If this acknowledgement is lacking, then regardless of all the legal finesse and arguments we use, our judgments will have no effect. But acknowledgement can also come from within the court system. The courts will respect the judgment of the other courts. If we understand this judicial system in a broad sense, then recognition can be based both in national and EU courts or in the courts of the other EU member states. This judicial acknowledgement is becoming a very, very important factor in defending the independence of the judiciary against populism. A kind of a bypass, maybe, substituting the lack of acknowledgement from the side of legislative or executive power. But this bypass cannot last long. That's another question. In connection with it, this paradigm of thinking about judicial cooperation in the area of the European Union must be changed as well. An examination of whether a court decision of another member state is a judgment of an independent and impartial court or judge cannot be purely formal now. Perhaps it would be worth creating an institutional mechanism inside the European judiciary for permanent assessment, screening of the state of independence of the courts and judiciary in given EU countries. Something like Venetian Commission, open for the other courts. This would be helpful in deciding on specific matters by very simple courts, somewhere in the small town in the provinces of Spain, Poland, or Germany. Second, we need to change the paradigm of thinking about time. Populism doesn't work according to clocks hung in the noble courtrooms. Speaking by the Court of Justice or the European Court of Human Rights on matters related to judicial review standards after years from the time the dispute arose is completely ineffective. It has no sense. It is like giving birthday wishes after the death of the birthday boy. Third, decision of the highest judicial authorities of EU countries relating to EU standards on judiciary, or maybe not only on judiciary, must take into account the perspective and significance of these judgments for the other member states. This is the case of the judgment of the General Constitutional Court. Perhaps it was not enough, or perhaps it would be enough. It was enough just to change a little bit the language. Maybe it was enough to add some reservations. Maybe it was enough just to add a fragment explaining the German specificity and the fact that it cannot be transferred to other countries or the entire union. Maybe it would be enough and it would help a lot. And the sixth, lawyers. Populism is not able to subordinate independent institutions without the help of lawyers. It is unable to fill the courts with obedient employees without the help of lawyers. Without at least silence of lawyers, challenging the rule of law would be much more difficult. The paradigm of lawyer education and the legal profession must be changed. Much greater importance should be attached to the ethical principles of exercising these professions and sanctioning violation of these ethical principles. In this perspective, the activities of reliable judicial and prosecutors associations are very important. The Polish experience of previous years indicates the importance of the role of these associations in defending the independence of the judiciary. The profession of lawyers is a vocation. Do our students understand that? Every lawyer is ethically obliged to protect the value of the rule of law. The lawyer is not just a hired employee for good money for any purpose the client wishes. He can practice his profession only by promoting the rule of law. We should develop these ethical principles that should be followed by lawyers also in the time of crisis, of conflict with populism. And seventh, the last thing, caution. Where there has not been yet a crisis, or where there have been opportunities to return to the rule of law, it is now very necessary to introduce changes and reforms that will strengthen the functioning of institutions protecting the rule of law against populism. Tradition and legal culture is a beautiful thing, but against populism, it cannot replace real guarantees. Arguments like, I've heard it sometimes, in our case, in our country, the Minister of Justice would never take it seriously, would never take the steps against judiciary. It wouldn't be possible. After the experience of populism, the real populism, it only raises a smile of pity. Legal tradition implies a community of values. The power of legal tradition is also based on the common method of legal reasoning. When someone shows up who turns the table over, who denies these common values and begins to interpret the statutes according to other reasoning, legal tradition can no longer defend anything. That is why the reform must be started now, immediately. In this country, who can do this still, as long as rational legal reasoning still has some effectiveness. Also in the area of lawmaking and social persuasion. And at the end, anecdote. Once we met young Austrian criminal law scholars. In Austria, there is a very old regulation of recidivism in criminal law. I'm dealing with criminal law, that's my profession at the university. So this regulation allows, based on a very general and unspecified premises, to deprive persons who have already served a sentence. Very traditional solution. We asked our Austrian colleagues if they were not afraid of these provisions, that this provision could be abused somehow, especially by populist politicians in power. They told us that it would not happen because the Constitution forbids it. To our question, what would happen if such abuses still will happen? They answered that this is the pure theory because the Constitutional Tribunal, Constitutional Court would forbid it. You know, their imagination was beyond their reach. But it is the lack of caution. Thank you very much.
Thank you very much for this highly stimulating presentation, which gives us wonderful amount of great topics to discuss. But before we do that, we come to Angelika Nußberger, and I'm sure that she will give as a flamboyant introduction as we just heard. So please, Angelika, the floor is yours.
Thank you so much, Armin. I'm the fourth in a line of speakers, and I'm very happy to be here and to be able to comment. And I just want to make three remarks on President Gersdorf's speech, three remarks on Judges Maidowski's speaks, and then three more general remarks. And I will try to weave in some thoughts as a response to this really excellent presentation by my Polish colleague, Judge Wróbel. So first, just to take up what President Gersdorf said, I think her insights is extremely valuable for us to understand because she's a voice from within. And there I want also to position us. We are the neighbors, we are the outsiders. And the first thing we have to do is to listen to what our Polish colleagues tell us and explain us about what is happening. And that is what I want to stress about Mrs. Gersdorf's speech. She shows us a split society and also a split community of judges. And that makes us very thoughtful. We see that politics is divided. But I still want to stress that for us as outsiders, as bystanders, we have just to accept that there was the majority voting for a system which adopted, if I am informed correctly, within 2 years, 13 new laws on the judiciary or concerning the judiciary. So that is what we see, what we have to what we observe, and there is what's coming in, what Judge Wróbel explained, that civil society, as I understand, lawyers and actors, they have to be active from within to change, and I think change can only come from within. My third remark to what President Gersdorf has said, she used very, very hard words. I have read the translation of her speech. I was not able to follow it technically now, but I think that it was the same text. In this translation that I have read, she used the word dictatorship and she used the word authoritarian. And just to add a very hard statement, in one of the opinions of the Venice Commission, it stated that what is happening in Poland is literally worse than what happened in the Soviet Union. So these are very hard and strong words, and I want to put them into context to what Judge Wróbel just explained, because I think it's not specific. It's true. It's a general movement, and it's probably not helpful to look back to the past, but it's a new challenge. And the challenge for us all is mainly that our model of rule of law, which we thought is so well accepted that you just cannot be against it, that this is not accepted anymore in the universal way it used to be accepted. And that is what was called now technical, Judge Wróbel said, technical populism. And I think there is so much truth in these statements. It's a very, very general attack, and it can happen in any of our EU countries or European countries. So these are my statements to Mrs. Gersdorf's speech. Just a few statements to Mr. Maidowski's, Judge Maidowski's speech. What he said about rule of law, that rule of law is us, it's we are all responsible first. He said that there is no prefabricated model that we can just adopt, but rule of law has always to be developed and will be different in different countries. That it's necessary to have red lines, and then it can be endangered from within. I just sign all these statements on rule of law. That's my first statement. My second statement is that what he said makes reflect me on the relationship between diplomacy and law. I very much understand his answers to how he explained the judgment of beginning of May, and I think what we see here is a clash between the logics of law and the logics of politics. Because as a lawyer, you say you just work on your judgment and you wanted to be consistent within. You don't check if it's the good day to publish it. You just publish it when it's ready. But there, I think I have to put a question mark, because judges at constitutional courts and judges at international courts or European courts, they have a special responsibility. And I wonder if you don't have, if you can really just go ahead with this logics of law. There is a responsibility. I remember when at the European Court of Human Rights, we had to adopt a judgment on Yulia Tymoshenko. It was absolutely clear that it's a decisive difference if we adopt it before the election or after the election. There is no neutral point in time. And there I want to take up the valid point made by Judge Wróbel about time. Yes, our judgments very often come too late, and we have to think more about time. I have no real good answer, because what can you do as a judge? We always said we just continue working and then we adopt it when it's ready. But we have to see how it's taken then from the outside world. And the third statement to Judge Maidowski, he explained that the German Constitutional Court's judgment cannot be taken as an example for the Polish attitude to criticize the European Court and to find a way of not following the judgments. But I just want to say that Judge Maidowski started out by saying that rule of law means also if you dislike a judgment, you still have to obey. That is necessary for the authority of the judgments. And to create an exception, or as it said, an exceptional exception, or an exceptional exception, still means you don't always obey when you dislike it. And you find this loophole. And this loophole will be used, and it will be used out of context. And I think it's not possible for a judgment to define, to say, you can use it only for this and under these and that conditions and circumstances. If it's used in a way to say, we abide by the judgments almost all the time, but we make an exception. And that is where I see the real danger for the European legal community by this judgment. And I'm not sure, Judge Wróbel, if just a remark that is specific, a specific answer from a German court would have helped in this way. I'm a bit skeptical. And now just three general remarks. I mean, yes, we can, how can we, what is our task? We can look at the past, we can analyze the past, we can look at the present time and ask ourselves what is now happening with, for example, legal certainty. I'm absolutely unsure if you look at our jurisprudence based on the newest Icelandic judgment of the European Court of Human Rights, that when I'm out, do you still see me?
I hear you perfectly.
Okay, I was just, so I'm back in. Yes, we have the Icelandic judgment, which was referred to the Grand Chamber, where it said if the election of a judge is incorrect, then all the judgments adopted by this judge, by such a judge, are a violation of Article 6, right to an independent tribunal. So I wonder about the present situation in Poland based on this judgment, but we have to wait for the Grand Chamber judgment. But yes, let's look into the future. What can we do and what should we not do? The actors to react are basically is the Polish society, and there Judge Wróbel has shown us very important ways how to react, and I think that's true for all the countries. And just to take up one point, you said that education is very important. Just to inform you, we have in Germany, we have set up a foundation which is called Forumrecht. And the idea is to show the functioning of rule of law, of Rechtsstaat, because we all, for us all, even for us lawyers, it's quite something abstract. And as we have a house of history where you can go and can touch things, we want to set up a Forumrecht where you can sort of touch the Rechtsstaat and where you have vivid discussions, where you integrate theater players, where you go to schools. So I think we are aware of that. It's a value we have to keep, and we have to do something for that. And I also completely agree that the language of our judgments might be rethought. Judge Maidowski said that there are 40,000 words. I ask, to whom are these 40,000 words directed in this judgment? The general community will not read these 40,000 judgments. They are for the legal community, but there might be also a question mark if I think of the Lüth judgment, which was some 20 pages and had a very strong message. I wonder if we lawyers are not sometimes driven by wanting to make it perfect, and then we create some text that is not read by everybody. So who can react? The Polish people, the EU neighbor countries like our countries, and in the next round, the question will be posed about the German presidency, and the Council of Europe, the European Court can react. I want to ask, perhaps on a general basis for us for discussion, should we react with, and now I ask for us lawyers, should we react with soft law or with hard law? I see really a dichotomy of reactions. Hard law is what the European Court in Luxembourg did, adopting judgments that are difficult to swallow, And then you have the real problem if these judgments are not abided by, if they are just rejected. Then you create a very, very general problem for the authority of the court in Luxembourg and for the authority of courts in general. The same is true for the European Court of Human Rights, where we had now complaints communicated about the situation of judges. When the court hands down judgments in such cases and they are not followed, we create a big problem. So hard law is better, of course, it's more effective, but if we are already at a point that it's not followed, we have a big problem. So in this sense, I really also advocate soft law. We have a lot of soft law instruments in the European Union, but we also have soft law instruments like the Venice Commission, which was already mentioned. Just last Friday, we have adopted an urgent opinion on Poland on the last changes and reforms. That is also quite a quick reaction. So I wonder if the situation that we are seeing, observing right now, does not call for materializing these instruments more. So my fear is, and there I take up a little bit the example or the metaphor of the house, but in a different way, used by Judge Maidowski in a different way. I'm sometimes afraid that reactions like those of the European Court in Luxembourg are like a fire brigade, extinguishing the fire, trying to extinguish the fire, but flooding the house, and then you have more water and you still have to tear down the house. So this is my real fear, because what I think is at stake is basically trust. The judiciary lives only and is efficient only if it's trusted. And that is true very much in Europe. And I see a lot of attacks on this trust in the judiciary right now. And that is what worries me most. Thank you very much.
Thank you very much for this very thoughtful presentation. I think we now should have a first round of reaction among the panel, including Judge Maidowski. So I'm asking Judge Maidowski, would you like to come in and give some comments on what you have just heard?
Yeah, thanks everybody. Mr. Wróbel, it was a pleasure to listen to you. I couldn't agree more with everything you said. The threat of populism is what we experience in Germany as well. A very tiny, small remark on one of your points. You talked about language, contemporary language. We do so as well. In our deliberations, it often takes hours or days to talk about our language. And, well, we do use the language of the 19th century now and again. And I agree with you that we should be modern in this point. But there's one little aspect I'd like to underline. The populism works on the thesis that everybody can judge on legal matters. So we don't need the courts. Weakening the judiciary is always the first step we experience when populism grows strong. So what we, I think, need is a twofold practice. On the one hand, we should underline that law is sort of an expert matter. Law, as you all know very well, is so extremely complicated now and then that it is not possible for everybody to cope with any legal matter or problem or question which is discussed publicly. What I think we need is to talk about our decisions in a language that everybody can understand. But there are effective limits to making the 40,000 words Mrs. Nußberger complained about understandable for everybody. So I don't have an answer which might be nice just now, but I think I take with me and in our panel your idea of modern language, but as I said, I want to stress that there are limits to this approach. Yes, Mrs. Nußberger, I was glad that you had only 3 remarks on my speech. That was nice of you, but indeed you cheated a bit because the 40,000 words was a 4th remark. Anyway, why did we take our judgment right now? It was the wrong timing, obviously, because we are in midst of a crisis and everybody, well, has other things other questions to answer than just talking about a program which dates back a couple of years. But then still, diplomacy is a way of putting things in an understandable way. But for us as judges, we've discussed this matter a lot, and we've postponed the May date for about 2 months in order to have the technical possibilities to utter the judgment in a proper way. But we thought very strongly that it would have been unfair to postpone, say, another 6 months, because the European Central Bank obviously is setting up the next program, and not talking about our ideas about the PSPP program would have been unfair. They have not been part of our proceedings, but they are sort of addressees, and not knowing about our undiplomatically formulated judgment would have put them in a very difficult position, I think. So that's why we decided not to wait. And as judges, as you said, it takes years. For us, it has taken 4 years to get along with this case. And as you know, I'm talking about the majority vote. So in our deliberations, the room, it was not always the friendliest atmosphere. But having come to an end, everybody, all of us, all the 8 of us, thought that we had the duty just to let go, to tell everybody what we have decided, and then wait for the criticism. What we do since. So the time problem. The exception problem. There, I'm afraid, I don't have an answer you might have sympathy for. Because obviously, you're right. Life would be easy if there would be only one solution: obey the decisions of the European Court. We have been talking about an exception, in our understanding, occurring every 20 years. It has been the first in very many more years, the first time we didn't accept part of a ruling of the European Court. But the system we've set up, and the court has set up before I joined the court, as you know, bases on the idea of the identity of our constitutions. There are limits we cannot exceed. There are limits we have to respect. And if we want to change, really change,
Judge Maidowski, you are frozen, so perhaps, thank you. Yes, you are still frozen, we can't hear you. So perhaps I have to come in with two pieces of information. The first is that we need to finish in 10 minutes because the commissioner wants to come in at 11:50. And I'm also informed to ask the general audience. So please, all these people, the 800 or more souls who are listening, there is at least a short possibility to ask questions. So please mail to questions@dimr.de, Deutsches Institut für Menschenrechte.de, dimr.de, to ask at least some questions, which will be highly interesting to us. At this point, Judge Wróbel and Judge Nußberger, perhaps you can also have a short reply among yourselves, and then we hope that there is time for at least one or two questions. So please, Judge Wróbel.
I don't hear.
You have to unmute yourself, please. Yes.
I was not so much criticized. I'm only happy that we agreed in many questions. Though while hearing to Judge Maidowski, which is perhaps not very gentle to speak about him without his presence here, but oh yes, he's coming. But I think that what lacks, personally, I was touched by it. I didn't have much trust to the Constitutional Court of Germany that there was enough reflection on the influence of this verdict, of this decision on the other countries. Because otherwise, I would find something there in the reasoning of this, in this 40,000 words about this. And you know, it is only I have it for granted that you discuss it very deeply in this room, and you make the great deliberation on that. But let's give the sign of that.
Excuse me, we need to come to Angelika Nußberger, and then there is Dr. Baranowska, who also wants to come in, and we have just 9 minutes left, so please be patient with me. Angelika.
Yeah, but I think I need to hear the rest of Ulrich Maidowski's answer, because he was just about to say that he disagrees, and I want to understand. You just started with the exception problem.
In my opinion, I just ended with the exception problem, but that might have been lost in technique. I don't know. What I wanted to say is that this is a point we won't have an agreement upon. But as Mr. Wróbel just now said when I rejoined the meeting, was what I do like to do and what we all should do very much more than we did, to keep up the international contacts we all haven't had. In my experience, those contacts have grown very difficult with Poland, with Hungary, with Turkey, with all those states where populism is very strong. But what we need is the professional contacts between ourselves and the colleagues, and well, to the media in Poland, to everybody there who wants to listen to us and who wants to discuss matters. Because if we had more opportunities to do so, there might be more understanding. For me, it is, I know I have to explain that our deliberations, of course, touch political aspects and philosophical, ethical aspects and all that. For me, it is a matter of everyday work. But outside our building here, nobody knows so, maybe. So what we can do to come a bit closer to each other, we won't agree on the point of exception fully, but to come closer to another is to have more conferences, talks, meetings, and whatever. That's a very practical and a very small point, I know, but it's a deficit we have, and we could do much more in this direction. As I know, the judiciary along the Polish border in Germany has huge difficulties to keep up the contacts to the Polish courts. which is a pity. And the populism in Poland, the government in Poland, needs to stop those contacts. That's why we need to keep them up. That's what I wanted to say.
Yeah. Thank you very much. Angelika, further reaction from your side?
Just very, very short reaction because of time. I just claim, having worked in a European forum for many years, I just claim, Judge Maidowski, that we are responsible for being misunderstood. I think we are really responsible for the possibility of being misunderstood. And I just want to mention the Gurgele, which also comes from your court. And as you know, the Russians have now adopted a judgment and bring it these days now into the constitution, a mechanism not to follow the judgments of the European Court of Human Rights, based on the famous last word of sovereignty that is always the reference. So, I mean, that's not how you meant it, that's for sure, but that's how it's received in other countries. And we are no longer judges who decide only for a specific country, a specific region, but we are read everywhere, and we have to be aware of how we might be misunderstood.
Good point.
Now we have 5 minutes, and Dr. Baranowska, please come in, and perhaps you want to ask a question from your side, as time is so short, please come up, show up, and be part of the panel.
Hello. So first of all, thank you for all the great questions and comments that we have received over the last 2 panels, and keep them coming. We are reading them as they come. So I would like to start with one interesting comment that we got with regard to safeguarding versus restoring the rule of law. And that speaks to populism, one of the topics that all of you have mentioned in your speech, as well as to other comments as hate speech and fake news and other issues in Poland mentioned by Judge Wróbel. We also received one of the comments connecting the rule of law to women's rights in Poland. And the general questions that would come out of those comments and questions is, can restoring the rule of law be done with respecting the principles of rule of law, and what's the difference here between safeguarding and restoring? And in particular, we were asked about Poland, but also Hungary.
Thank you very much for that question. There are 4 minutes left. That makes 1 minute for each of the participants, and that should also be your final comment. I'm sorry we don't have more time. So we might go in the inverse order, and we start with Angelika Nußberger, then Judge Wróbel, and then Judge Maidowski at the end, if you agree with that. So yeah. Please, Angelika.
In 1 minute, just to take up one of the questions asked, how can you restore rule of law if it's already gone the wrong way and then you want to come back? I think that is a central problem, because you have, for example, the principle of the irremovability of judges, and now you have new judges. So the principle of irremovability applies to them as well. So there I see a huge problem, but that's all I can say in 1 minute.
Thank you very much. That's Wróbel.
I can only agree with you. You know, it's the thing I'm wondering all the time, just thinking how to do this. It's the most complicated problem I have ever thought about in my whole scientific life. How could you develop a doctrine that would protect the judiciary from the new political equipe that will come, for example, yes? Because you can restore it using the politicians of the new regime, let's say, of the new movement, but then how to keep it safe and stable in the next political turn, yes? Because once you let the politician inside and build and rebuild the whole system, then you can't stop them. I don't know.
Thank you very much. I can suggest to you to look at the ideas of the opposition in Venezuela. They are facing the same problem, and they have been working it for a longer time. They have very interesting ideas how to rebuild the judiciary in a rule of law way. That's a complex thing for another seminar. Now we come to Judge Maidowski, please.
A Hungarian judge once told me that he feels to be forced to decide certain cases as the government likes them to be decided. But he takes the freedom to decide all the smaller cases following the rule of law. I don't know if this is a good idea, splitting judges in two halves. I'd rather not. But what I think we can suggest is start with the small cases, with the lower instance courts. Start to restore the rule of law in the heads and in the hearts of judges working there, and do it by international contacts. And then things will build up, hopefully. I don't think it's a good idea to start at the highest point you can possibly get, the Constitutional Court, if this court is lost. But start at the first instance courts. It's where everything starts in our judiciary. Yeah.
Thank you very much. That has been a wonderful panel, and we even finished precisely on time at 11:50. Thank you very much for the contribution. Thank you for being so disciplined. I think it has been a great moment. So I hand over to the organizers. Thank you and goodbye.
Ja, ganz herzlichen Dank.
Yeah, thank you so much to the four of you. I have to say, especially the moderator, Armin von Bogdandy. You handled that very well to keep to the schedule. You all noted we need more talks, more intensive debates about these topics. We had a chance to start that. Unfortunately, this electronic format is not appropriate for having full-day meetings. This is why we have to stick to the limited time frame. So this is unfortunate, but it worked out well. So thanks for that for the moment.